Once your claim has been lodged and the response has been accepted, the tribunal will set down a list of directions. These are a list of tasks that each party needs to comply with and to produce to the court or to the other party. The first step is to produce what's called a schedule of loss, which is a breakdown to the court of what compensation you're seeking if you win your case. For unfair dismissal claims, the compensation is capped at usually a year's salary, but in discrimination claims there is no cap on the level of compensation a court can award. If you do go ahead and bring a claim for unfair dismissal, then you have a duty to mitigate your loss, which means to take steps to find new work, to sign up to job agencies, to reduce the level of loss that you have suffered. And if you fail to do so, a court can reduce the level of compensation on the basis that you have failed to take steps to mitigate.
Of course, as a company, you're going to want to scrutinise the figures that the employee is presenting in that schedule, and if necessary, produce a counter schedule of loss. If, for example, the employee has secured employment elsewhere, you're going to want to know what the rate of pay is and when they secured that employment, so don't be scared to ask for documentary evidence to corroborate those payments.
Following the submission of the schedule of loss, there is usually a requirement to submit a list of documents. As the name suggests, this requires both parties to put together a list of all the documents that they rely upon, whether that be a document that helps or hinders their case.
Generally speaking, it will be the respondent or the employer's responsibility to prepare the bundle of documents, and it's that one agreed bundle that both parties will rely on once the claim gets to a final hearing.
And once you've got an agreed bundle, you then have the opportunity to submit witness statements. Once the bundle has been produced, each party will be required to submit a witness statement. This will need to be in your own words and will be your version of events leading up to the claim that you are bringing. You will also have the opportunity to rely on other witnesses who may have been present when the incident occurred, which may bolster your case. However, in practice, we often see that colleagues are reluctant to come forward when they are still working for the employer because they fear they may lose their jobs if they help you.
From the company's perspective, it's important that you seek to rely on witnesses that can corroborate your version of events in your defence. So, for example, with a claim for unfair dismissal, typically you would expect to call upon the investigating officer, the disciplinary officer and the appeal officer. It's important to bear in mind that these individuals will be asked to attend a final hearing. So when a final hearing date is being decided, it's important to bear in mind your own witnesses' availability to attend. A failure to attend is seriously going to undermine your defence.